Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 95, closing in on that magic century. Well, in this podcast we're looking at, as always, three recent cases, and the first is HOTAC and the Secretary for Foreign Commonwealth Affairs and the Secretary of State for Defence. This is a Court of Appeal decision on territorial jurisdiction for discrimination cases. Secondly, we've got Pendleton and Derbyshire County Council and others, which looks at an innovative discrimination claim. And finally, CA, RA, RB and RC, who are all four anonymised individuals, and News Group Newspapers Limited, dealing with, surprise, surprise, restricted reporting orders. As usual, don't forget that you can access the podcast via iTunes. It's on the Mayor Brown Internet or YouTube, and my Twitter feed, Nicholas Robertson at NicholasRobert11, and that's also where we post out links to all the cases we discuss. Finally, just by way of a change, at the end of this all, I have an apology to make. So, first case, HOTAC and the Secretary for Foreign Commonwealth Affairs and the Secretary of State for Defence. This is a case involving territorial jurisdiction for discrimination claims. It's an important case because it's really the first time the courts have grappled with the issues around discrimination claims for individuals working outside the UK, well, at least in a reported decision that I could find. As I shall explain, so far we've primarily been dealing with unfair dismissal claims for employees working outside the UK. Let me start with the facts and then we'll move into the law. It's not an employment claim exactly, so I'm going to deal with the facts relatively briefly. The two individuals were interpreters for the British Armed Forces in Afghanistan. For various reasons, they wanted to claim indirect discrimination. As I say, it's a non-employment context, but the parties accepted that the provisions of the Equality Act 2010 govern the particular discrimination dispute. Their claim in the High Court failed because the High Court held that the individuals did not qualify under the provisions of the Equality Act 2010 for protection. I'm going to summarise the law on this in a second, as I say, but in essence the High Court found that factually the individuals did not have a sufficiently close connection with Great Britain and British employment law. The contracts employment they worked under contained no suggestion they were subject to English law. They didn't say that English statutory provisions would apply. They were governed by Afghan law, and there was no physical contact or connection to Great Britain at all. They were local staff, locally engaged on local, albeit vital, support. In truth, the judge in the High Court said the connection to Great Britain was limited to the identity of the employer, i.e. the British government. As such, they did not have a stronger connection with Great Britain and British employment law than with Afghanistan and Afghan employment law. So, what's the law in this area? Well, as is well known, the Equality Act 2010 does not set out specifically in what circumstances individuals working outside the UK can rely on the provisions of the UK discrimination legislation. The Equality and Human Rights Commission's statutory code of practice states there has to be a, quote, sufficiently close, unquote, link between the employment relationship and Great Britain. In a parallel set of cases considering the same issue for unfair dismissal under the Employment Rights Act 1996, the courts have developed a test to replace the former statutory test. Depending on when you started doing employment law, you may remember under the original formulation of the Employment Rights Act 1996, individuals who ordinarily worked outside Great Britain were expressly excluded from claims of unfair dismissal by virtue of Section 196. However, that statutory provision was repealed. Following that, in cases such as Lawson and Serco, Ravat and Halliburton and others, a test was formulated in the context of unfair dismissal to ask, is there a sufficiently strong connection with Great Britain and British employment law? Both aspects of that have to be met. You may remember in an earlier podcast we looked at the Dunner case, which said it wasn't relevant to consider whether employment law in the alternative country offered similar levels of protection to British employment law. So, the question put very simply in this case was, is the test for deciding whether an individual working outside Britain is entitled to claim protection from discrimination the same test as the test for unfair dismissal? Then, secondly, the issue is whether the facts in this case did amount to a sufficient link. Here, the Court of Appeal give a clear answer to both questions. They said there was no suggestion in their minds that the jurisdictional test ought to be different for discrimination claims. Quote, there is much to be said for jurisdictional symmetry between claims under the 1996 Act and under Part 5 of the 2010 Act. Unquote. The High Court had been hesitant on this point because the judge recognised that in some circumstances rules on discrimination can vary radically between different countries around the world. And there might be cases where issues of the interrelationship between legal systems became a particularly thorny issue. There was also an attempt in the Court of Appeal to argue that because the matters related to discrimination were going to the, quote, very essence of man's humanity to man, unquote, there ought to be a wider territorial test for claimants for protection from discrimination. But the Court of Appeal rejected that roundly. They said clearly it could not have been intended to have worldwide jurisdiction, because if that had been Parliament's intention, it would have said so. And they're not willing to read into a completely silent test, bear in mind the legislation doesn't address the problem at all, where that there ought to be a different test for discrimination when the unfair dismissal legislation is equally silent. As the judge who delivered the leading judgment in the Court of Appeal said, quote, to impute to Parliament an intention to engraft onto that test an unidentified qualification to the effect that a more generous standard is to be applied when the relevant inquiry is the availability of the discrimination provisions in Part 5 of the 2010 Act is a course I would regard as artificial, unjust and unwise. Full stop. I will decline to do it. Unquote. Don't you just hate it when judges sit on the fence? Well, at first sight, this looks like an eminently sensible approach. A claimant who wishes to claim unfair dismissal or protection under British discrimination laws needs to demonstrate a sufficiently close connection with Great Britain and British employment law. The same test applies to both. But one thought struck me, and I have no idea whether this case is going any further, and of course other cases may arise. I remember when the territorial jurisdiction provisions were taken out of the Employment Rights Act 1996 and the then equivalent discrimination provisions. The tests at that point for discrimination and unfair dismissal, and when individuals working abroad qualified for that protection, well, those tests were different. Under unfair dismissal, the test was whether the individual was ordinarily working in the UK. However, it was possible for individuals working abroad to claim discrimination or claim protection from discrimination in circumstances where they couldn't claim unfair dismissal. Under, for example, the Employment Equality Sex Discrimination Regulations 2005, the test, in the context of sex discrimination, was as follows. The individual was entitled to protection if he or she worked at an establishment in Great Britain. There was a deeming provision that said you were deemed to be employed at an establishment in Great Britain if you did your work wholly or partly in Great Britain. Alternatively, if you did your work wholly outside Great Britain, and either the employer had a place of business at an establishment in Great Britain, and the work that the individual was doing was for the purpose of the business carried out at that establishment, or the employee was ordinarily resident in Great Britain at the time he applied for or was offered employment, or at any time during the course of employment. In other words, an employee who only worked for a small minority of his time in Great Britain would qualify for protection. An employee who was ordinarily resident in Great Britain when he was offered employment or applied for it could be deemed to be working in Great Britain if the work they were doing was for a business with an establishment in Great Britain. I think it's most unlikely that the current law extends that far. In other words, there was a different test, and the effect of creating the same test is to reduce the discrimination protection for claimants working abroad compared with what it was before. And just as I'd accept entirely that if Parliament intended to create a separate test, it might have been expected to say so. But if Parliament intended to reduce the protection to those claiming discrimination, maybe it would have said so too. Anyway, for now, we have a very clear statement from the Court of Appeal that the same test applies. It's a common test, and you're looking at establishing there's a sufficiently close connection with Great Britain and British employment law. And certainly, from a policy reason, you can understand why it'll be easier for employers and employees if they have one test only to apply to the facts. And as the number of internationally mobile workers increases, cases like this are going to become increasingly common, and well-advised employers are going to look to structure arrangements in a way that they know what their obligations are, rather than getting caught out treating employees in a particular way and then inadvertently finding out they've given rise to claims in the UK. So that's the case of Hotak and the Secretary for Foreign Commonwealth Affairs and the Secretary of State for Defence. Next up, Pendleton and Derbyshire County Council and others. One of the more interesting aspects of doing the podcast is seeing the way in which people make creative use of particularly discrimination provisions, sometimes also the whistleblowing provisions, to try and obtain protection in circumstances where that might not have been your first reaction. And this is really one such case. The facts of the case, very briefly, with Ms. Pendleton is a school teacher, and she's also a practising Anglican Christian. She worked at a junior school. She met and married another teacher, Mr. Pendleton, who worked at another local school. It was a separate school, but inevitably there's a certain amount of crossover and contact between the two schools. He was arrested and eventually convicted for downloading indecent images of children and voyeurism, and there was never suggested at any stage that his wife had been aware of the activities before he was arrested. However, her employer made an increasing number of comments to her about the dangers for her if she chose not to leave her husband, but remained as a teacher. Eventually, a disciplinary investigation was set up, and she was charged with gross misconduct based on the erosion in her ability to carry out her safeguarding responsibilities as a teacher because she had failed to leave her husband. She was suspended, and the month after he was convicted, she was still standing by him, and she was dismissed. Her position was that she felt she should not have to choose between her marriage vows and her career. She also believed that she should stay with her husband because he had wholly and completely repented of his actions. And this was in line, she said, with her obligations under her marriage vows. So, she's going to be dismissed for gross misconduct in these circumstances. It's obvious there are going to be issues around potential claim for unfair dismissal, potential claim for damages for breach of contract. But she also brings a claim for indirect religious discrimination. The claim for religious discrimination was made under Section 10 and 19 of the Equality Act 2010, by way of a quick reminder, and I promise you it's relevant. Indirect religious discrimination occurs if A applies to B, a provision, criterion or practice. This provision, criterion or practice puts, or would put, people of B's religion or belief at a particular disadvantage when compared to people who do not have that particular belief. B, in this case the claimant, so the claimant has to suffer that disadvantage. So, in my simplistic terms, you apply a neutral rule which disadvantages disproportionately people of a particular religious view. It's then open for, in this case the employer, to justify that provision, criterion or practice and say it's at a proportionate means of achieving a legitimate aim. Well, at the employment tribunal stage, the claimant won her claims for unfair dismissal and gross misconduct, but lost her claim for indirect religious discrimination. The tribunal agreed that the claimant had a religious belief, namely that marriage vows are sacrosanct, and that was an expression of her religious belief. No surprises there. It also went on to accept that there had been a provision, criterion or practice applied to the claimant, which it said was a policy of dismissing those who chose not to end a relationship with a person convicted of making indecent images of children and voyeurism. That finding gets appealed by the employer. They said there was no such provision, criterion or practice. However, the employment tribunal had gone on to find there was no disproportionate disadvantage, or group disadvantage if you like, to those holding the claimant's religious beliefs when compared with those who didn't hold the religious beliefs. As the tribunal put it, anyone who elected to stand by their partner in the same circumstances would have been dismissed. Those who share the claimant's religious convictions were at no greater or lesser risk of being dismissed. Therefore, according to the tribunal, the employer did not place the claimant at any greater or particular disadvantage with those who, compared to her, did not share her religious beliefs. The tribunal also pointed out that those who shared her religious beliefs might well have chosen to leave their spouse in those circumstances, and therefore, on that basis, the tribunal rejected the claim. And this finding about lack of disproportionate disadvantage was appealed by the claimant. So that all sounds very sensible, right? Well, the EAT dealt with both points in a very clear judgment. And first, the EAT pointed out the Employment Tribunal had asked itself whether there was a policy, when in fact the statutory wording refers to provision, criterion or practice. But they said this didn't matter. They acknowledged that if something was a practice, it was likely to be something that involved some degree of repetition. Wasn't this a one-off situation, said the employer. Well, the EAT said, you could have a practice which would be implied in the unlikely eventuality that the same circumstances arose again in the future. That could be a practice. There can be a practice, even if it's the first time the practice has been applied. Since the employer's position here was that it would have dismissed others in the same situation, then this could be a practice. And I think that's an entirely sensible way, if I may say so, of distinguishing between the first time a practice has been applied and a one-off error, maybe, like a badly handled disciplinary proceeding where something goes wrong, but there's no reason to suppose that the same approach will be adopted next time round. The EAT also moved on to address the issue of whether or not there was disproportionate disadvantage. And here, the claimant won. The EAT took the view that there was evidently indirect discrimination. Anyone in a long-term relationship forced to choose between their partner, whether married or not, would be placed in a terrible dilemma. However, those with the claimant's religious views would have an additional crisis of conscience to deal with. Other groups too might have a crisis of conscience, but it still meant that this group, i.e. Anglican Christians, would have an additional burden, a particular disadvantage. Since the employer, for whatever reason, had not sought to lead any evidence to suggest that the decision to dismiss was justified, if it was an indirectly discriminatory provision, criterion or practice, the EAT then substituted a finding the claimant was indirectly discriminated against on the grounds of her religion. Now, certainly these are an extreme set of facts, but I do wonder, when the employer here embarked on the particular path, whether they realised that the claimant's religious views had significantly increased their risks in driving through what looks, just from the case report, I have no other knowledge of the case, to have been a policy-based decision to shed a wife of a teacher convicted of significant criminal offences. So that's the case of Pendleton and Derbyshire County Council. So third and last case, CA, RA, RB and RC, the News and News Group Newspapers Limited. This is an EAT case dealing with restricted reporting orders. And one of the things we've certainly noticed over the last couple of years is the increased willingness of the newspapers to get involved in digging into employment disputes, especially if there are allegations of public figures engaging in sexual misconduct. Under the rules applicable to the employment tribunal system, there are two different ways in which parties to a tribunal can seek to protect themselves from the disclosure of the content or their identities. Firstly, under Rule 50 of the Employment Tribunal regulations, it's possible to make a restricted reporting order. This can apply at any stage in the proceedings and can prevent or restrict the public disclosure of any aspect of the proceedings insofar as the tribunal considers it necessary in the interest of justice or in order to protect the human rights of any person. However, the tribunals are directed to consider the principle of open justice and the right to freedom of expression under the European Convention. Alternatively, under Section 11 of the Employment Tribunals Act 1996, the tribunal can make an order that there is a restricted reporting order in cases involving allegations of sexual misconduct. That order, under Section 11, continues until the tribunal's decision is propagated, unless it is specifically revoked earlier. So there's a general restricted reporting order power, and there's one specifically in the cases for sexual misconduct, but which ends when the tribunal decision is propagated. But it allows the conduct of litigation to go ahead without interference, my term, from the newspapers. Well, in this case, one of the parties brought an unfair dismissal and sex discrimination claim against the other three individuals who were identified only by their initials. There are allegations of sexual misconduct inherent in them. The defendants applied for a restricted reporting order under Rule 50, but that was rejected. However, there were orders made under Section 11 pending an appeal to the Employment Appeal Tribunal against the decision to reject the full restricted reporting order. This was then backed up by an order under Section 50 itself, when News Group newspapers became aware of the allegations and applied to be heard at the EAT hearing to deal with the original application for a restricted reporting order. However, the case then settled before the EAT hearing actually could be heard. The question for the EAT, and the one they had to grapple with, was what did that mean to the restricted reporting orders? Did the Section 51 end automatically because the case was no longer going ahead? Did it mean that the restricted reporting order had to be left in place indefinitely because the case was no longer going ahead? Or was the whole thing still up for grabs? Well, the short answer was the whole thing was still up for grabs. The claimant had withdrawn her case as part of the settlement and confirmed that the case could be dismissed, but the case had not actually been dismissed at that point. In any event, the EAT decided that the tribunal retained jurisdiction to determine whether the restricted reporting order should be continued. On the particular facts here, the EAT upheld the tribunal judge's exercise of discretion not to grant the restricted reporting order. However, because the matter is going on to the Court of Appeal, the parties are covered by a restricted reporting order until the decision in that particular appeal is known. So on it goes. Well, clearly there are a number of celebrity injunction cases kicking around at the moment, and this looks like adding to the general law on these issues, but in a specific employment context. Certainly claimants are often quite quick to threaten publicity where they think it is merited, and even though some employers take the quote, publish and be damned, unquote, approach, reputedly first stated by the Duke of Wellington, I believe, in other cases, employers tend to take a very different view, and it's a very handy way for claimants of forcing an unwilling respondent to the negotiating table. But the main point to take away from this is that where parties settle a case, if there is a restricted reporting order in place, that's certainly something that needs to be addressed by the parties in that settlement. Otherwise, an employer may find they've paid out in the settlement, but the restricted reporting order can't be maintained, and the newspaper is then unable to publish the underlying allegations. Oh, and the only other piece of advice I have, if you have a client who's caught up in this sort of media feeding frenzy, buy them a copy of John Ronson's book, So You've Been Publicly Shamed. It's a really good book, it's fascinating, and it's really wise about the impact of an individual who is finding themselves at the centre of a media storm. So, that's the case of CA, RA, RB and RC and News Group Newspapers Limited. So, last little bit, apology. Yes, I owe an apology. At the end of the last podcast, and completely impromptu on my part, I have to say, I threw in the comment about the fact that I knew that Jon Snow was still alive. I was spoken to at the annual conference last week by someone who said, "Thank you so much, Nick, for spoiling that for me. I follow it on a box set, and in these circumstances, you've just derailed the big plot twist in the season I haven't yet got to." Sorry, didn't think of that one. Anyway, I just remains to leave you with news then that my eldest son, who is a massive Game of Thrones fan, but missed the last episode for various reasons, received an email from a mate of his who'd stayed up till 2 a.m. watching said episode, claiming that both Ned Stark and Khal Drogo were back and alive and what the hell was going on. For about 30 seconds, my eldest son believed them. Anyway, thank you all for listening, and until we do this again in 2 weeks' time, take care.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.